Good morning, Council. Welcome everyone to the Wednesday morning docket of the Kansas Court of Appeals. I'm Judge Anthony Powell, and I'll be the presiding judge this morning. With me are two very distinguished judges on our court. Judge Dave Bruns, who's been with our court since 2011, I believe, is with us, and also just recently retired Judge Steve Levin has also joined us, and I think it's Judge Levin's first panel on the court since he's retired, and we're very glad to have him with us today as well. We have two cases on the docket this morning, and the first one up is the case of JJ and DJ as next friends for DJ, a minor, versus Dalton and Mary Neeley and Farm Bureau Property Casualty Insurance Company, case number 122793. Could the court have the appearances, please? And we'll start with the appellant.
Good morning, Your Honor. My name is Todd Thompson, and I will be presenting the arguments for Farm Bureau Property and Casualty Company.
Thank you.
And I am Julie Gibson, and I represent the plaintiffs, Jake and Danielle Johnson, who Mr. Johnson is appointed as the next friend for their young daughter.
Very well. Thank you very much, counsel. Counsel, as just so you're aware, we allotted 15 minutes aside for this case this morning for argument. We have read your briefs, and so we're familiar with the facts of this case. Mr. Thompson, since you're the appellant, would you like to reserve any time for rebuttal this morning?
Yes, Your Honor. I'd like to reserve 6 minutes.
All right. You may proceed.
This is an insurance coverage case. It arises out of a garnishment. The garnishment relates to a judgment that certain family members obtained against their grandmother and great-grandmother in connection with a tragic incident in which the great-grandfather sexually molested his great-granddaughter. The judgment is technically on its face against the estate of the great-grandmother and grandmother, Mary, although the estate was never substituted as a party in the action.
Mr. Thompson, let me stop you right there. Seems to me this is a very fundamental question. Is there a valid judgment to be enforced in a garnishment action?
There is not. The judgment is void on for a number of reasons.
Why don't you explain that to us?
Well, the defects in the underlying judgment include the fact that there was no allocation of fault to the perpetrator. Now, seriously, can one look at the facts in this case and say that the perpetrator has no liability for the damages done to the minor plaintiff?
Before we get there, even before that, it's my understanding, and you just, I think, confirmed it, that the estate has never, even to this day, has never been substituted and is not a party. Is that correct?
That is correct.
So what we have is a judgment against a dead person.
Correct. Well, although the judgment itself states that it's against the estate.
It may state that, but how can you enter a judgment against a non-party?
I don't believe you can, and I think under 6225, there is not a valid judgment.
And if we do not have a valid judgment, then it could not be enforceable in a garnishment, could it?
That's correct. And there are other reasons why it's not a valid.
Right, you can go on, but I wanted to start with that very basic thing. And that doesn't necessarily mean the case is over or not. This is a minor. So there may be potential to still do some of that. But as we sit here today, it at least appears to me there could be a void judgment.
There is a void judgment for a variety of reasons. Another reason is this judgment, this $1 million judgment, arose from a trial with less than 10 minutes of evidence. The special administrator of the estate was not present, and again, not even technically joined in the case. These are all family members. It was an all in the family deal. There are no economic damages in the judgment, just non-economic, 500,000 for past and 500,000 for future, unrelated to any specific evidence.
Is it your argument that there needs to be at least some economic damages before you can award non-economic damages?
The argument is perhaps a little broader than that, in that all of these items indicate that, frankly, the hearing or trial or whatever you want to call it, and the entry of judgment was a charade, was not a legitimate testing of the circumstances of the case. I find it's a little different than in a case where you don't have non-economic awarded by a jury when you do have economic damages awarded. This is a little different than that, but frankly, even more bizarre to not have any award for all of the alleged counseling that supposedly had already occurred and supposedly will be needed in the future.
Mr. Thompson, why is the Farm Bureau, why haven't they waived any defects, at least with regard to sort of the allegations you raised about there's some proof issues or collusion issues? I mean, Farm Bureau declined to defend the Neeleys in this case. And so why haven't they waived those arguments? I mean, your client, Farm Bureau, they're not a party. They chose not to be a party or be involved in the litigation. So why haven't they waived those particular arguments?
I don't think, I'm not quite sure I heard which argument you were referring to, Judge, but I don't think we waived anything. And we are not a party to the lawsuit, the underlying lawsuit, until the garnishment, because there is no coverage. So
but your client had the opportunity to defend the Neeleys, to be involved in the litigation, to require the plaintiffs to, prove, every element of their case, and they made the decision not to do it. Why doesn't that then bar a challenge to, and I'm not talking about the issue of whether the judgment is void, but to the issues of proof and some of the allegations you make about collusion, those kinds of things. Why aren't they barred from doing that, given their unwillingness to defend?
But Your Honor, an insurance company can't just intervene in a case where there's no coverage and represent itself. Now, it could have provided a defense attorney for Mary under a reservation of rights, but it's not obligated to do that, and it's not bound by not doing that when there's no coverage. It has a right to not provide a defense when there is no coverage.
So they can just require a plaintiff to basically try the whole case again if they choose not to defend?
I'm not sure about trying the case again. It's never been tried, frankly, at this point. If an insurance company wrongly denies coverage and wrongly refuses to provide a defense, then they have freed up the insured, but there's actually insurance, to work out some sort of an arrangement. But here there is no coverage. So that's a completely different situation.
Mr. Thompson, if we get to the coverage question, do you agree that there aren't any factual disputes related to whether there is coverage such that we can decide that as a legal question, or is there some factual issue that needs to get resolved?
The uncontroverted and admitted facts in the record are sufficient to determine that there is no coverage under the sexual molestation exclusion.
Is there a bad faith claim?
That's a little hard to answer. You might have to.
That's probably why I ask it, because
ask the next counsel about that. I think their position is that there was coverage and that a defense should have been provided and was not. So that would be a definition of bad faith.
Well, bad faith, at least in my understanding, goes a little deeper than that. That is, you didn't have a colorable defense that there was no coverage. I mean, sometimes, and especially in insurance language cases, we can have legitimate disagreements over what that language means, and that's not necessarily bad faith. It seems like bad faith involves a little bit more than that.
Yeah.
For example, it's you clearly had coverage, you denied it, and then they can get a judgment not only for policy limits but in excess of that.
In this case, there is no coverage, and
Right. But what if we disagree with you? Hypothetically, let's just say there happens to be coverage.
If there was coverage, at the very least, Farm Bureau had a reason to think there was not coverage based upon this exclusion. I frankly don't think there's a sound reason for concluding with this exclusion that there is coverage. And
you don't think the Upland case or anything ties our hands?
I don't think that at all. Let's talk about that for a second.
Please do.
Johnson, you actually used up all your time.
Oh.
If you want to continue, we'll feed into your rebuttal time. Saved quite a bit of time for rebuttal. So,
well, let me go for 3 more minutes real quickly then,
okay.
And I'll reserve 3 for rebuttal.
You probably do want to at least discuss Upland and what we should do with that.
I do want to discuss Upland. Upland is not a rule that an insurance company has to cover everything. And in this particular case, we also have Jones and we also have Bug. We have cases that recognize damages exclusions, and that's what we have here. Raymer and Upland simply say that when there's an ambiguous exclusion, it has to be applied separately to each insured. And I want to do that. Let's apply this exclusion to Mary and see whether it applies. And it clearly does. The policy tells her at the outset, no policy can cover everything. That the following exclusions apply to all sections of your policy, and one of those is molestation and abuse. There is no coverage for any damages arising out of sexual molestation. That's as clear and unambiguous as it can be. These damages clearly arose out of sexual molestation. In the petition, it is repeatedly referred to sexual molestation as being the cause of the damages. And in Upland, Upland doesn't say that you can't consider the cause of the damages. If that is the express exclusion in the policy, not only can you consider that express exclusion, in the absence of an ambiguity, the rule in Kansas is the court may not make another contract for the parties. Even Raymer confirms that this is the rule. The function is to enforce the contract as it is written. And that's what we want you to do today, is to enforce the contract and the exclusion as it is written. In this case, the cause of the harm was sexual abuse and molestation. The damages all arose from that. If somehow he had not performed his perversities, but she had still let them be together, she had still failed to warn, she had still done everything they alleged she did, there would be no damages. The damages are absolutely, completely connected to the sexual perversity, the sexual abuse and molestation. The district court just ignored the provisions of the policy, didn't talk about them at all. And as a result, that was error and they must be reversed. The court must be reversed. Any questions before I?
Could I ask 2 real brief questions? One is, what's the policy limits here?
$100,000.
Okay. And I assume in light of the Kansas Supreme Court's recent decisions that there's no cap issue?
that's an interesting issue. There is no cap issue, but the judgment was entered when there was a cap in place, and that too was ignored by the district court.
Okay, thank you.
Anything else?
Thank you very much.
Good morning, Your Honor. Are you ready for me?
May proceed.
Very good, thank you. May it please the court. Let me address the issue that you raised initially about substituting the estate. When the settlement agreement was entered between my clients and Mary Neeley while she was alive, the agreement was a covenant not to execute on her personal assets and only to execute on the insurance proceeds under the Farm Bureau policy. She died, and her lawyer, personal lawyer, opened the estate, and at the trial, Roger Johnson, who was representing my clients at the trial court level, asked the court, and this is in the record in the trial transcript, to enter the judgment against the estate. That is, in effect, a motion to substitute the estate as a party. The pleadings were entered into evidence, appointing Mary's daughter as the representative. So I think that is a non-issue.
Okay, well, you can think that. To me, it's an issue anyway. And I certainly don't blame you. You weren't trial counsel, so you may not be able to answer this question. But I'm going to ask it anyway. And that is, why not just simply, I mean, in a case like this, why not just substitute the estate? It's pretty simple. It's done all the time.
Well, I guess there's nothing cited by Farm Bureau that says that motion to substitute the estate has to be in writing. And our position would be that request to substitute the estate was done at the trial level, and the trial judge did it when he entered the judgment. So
okay, so would you agree with me that if there was no substitution, we have a judgment really that's void, and so the garnishment would be unenforceable, and you'd have to go back and try to do it the right way for this minor child?
No, I don't agree with that.
Why not?
I think that Farm Bureau, for the reasons stated.
Let's take Farm Bureau out of it now.
Okay.
Farm Bureau's they're not a party yet. So we're not to the garnishment yet. We're trying to determine the validity of the underlying judgment, because to have a garnishment, you know, it's kind of like, this is a football. That's the thing we begin with if we're teaching football. The first thing you need is a valid judgment. So let's go back, and do we have a valid judgment? And what I hear you saying is that we have almost a de facto substitution here, that the record is sufficient to equate to an oral motion for substitution that was granted by the judge. Is that what your argument is?
Yes, and the entity that would have, the person that would have standing to challenge that would be the personal representative, and
well, if it's unenforceable, anybody could challenge it. This court could challenge it, because that would be a jurisdictional problem. So again, let's not get too wrapped up in it. Let's pretend there's no insurance at all in this case, that their Farm Bureau doesn't even exist. We're back at that level and just trying to figure out, is this a valid judgment? It sounds like your argument is that even though there's not a writing, that there was an oral motion for substitution that was granted.
Correct. And the judge, and that's codified by the fact that the judge entered the judgment against the estate.
Or is that just, well, I need to watch how I say this, or is that just maybe a way to circumvent the rules of civil procedure?
Well, I'd hate to accuse the trial judge of doing that, but I would disagree with that.
Okay.
Counsel,
I'm glad you did.
Can I just summarize what I'm understanding here? So we all agree that KSA 6225A, which you've clearly looked at because you're referencing the requirement of it in your answer to Judge Bruns, provides that if a party dies and the claim remains plausible, it's not extinguished, the court must, on motion, order substitution of the proper party. So the rule clearly contemplates there will be a motion. And if there's not one, then I think we would end up with a void judgment because we never brought in the estate. Your response to that is there was an oral motion made at the trial, and the oral motion was granted by the trial judge. And if I'm understanding the argument right, then we simply need to look at the record of that transcript to determine if that's a fair characterization of what happened.
Correct.
Okay.
Ms. Gibson, can you tell me again, the attorney who was representing the Neeleys, did you say that that was the same attorney that was also representing the estate as well? Is that the same person?
Yes. Yes. Mary Neely's personal counsel, and the name is escaping me, was represented her while she was alive and then represented her estate and the personal representative after she was deceased. The purpose in those pleadings, you'll see in those pleadings that are part of the record, when they went to open the estate, that the purpose of opening the estate was to finalize the settlement that had been reached before Mary had died. So yes, to answer your question, and he would continue to be copied on, knew what was going on, knew when the trial was occurring, copied on the letter briefing after the trial with the court about the damages and things like that. So
is the transcript of that hearing in the record?
yes, it is. In fact, it's in the appendix to our brief.
Okay,
Is there a place you could cite us to in that transcript that you would argue is the motion?
I would have to, let me see if I can find it. Oh, that's a motion for summary judgment. I maybe misspoke. I think that transcript might be attached to Mr. Thompson's brief.
Well, that doesn't add it to the record.
It looks like it's record volume 4, if I'm reading my information correctly, but I don't have it in front of me.
Yes, it is in the appendix of Mr. Thompson's brief, the transcript of the trial.
So was it made a part of the record? I mean, appendices are not part of the record.
Yes, it is.
Okay.
And I don't have that site in front of me. I probably have.
Okay, well, we can look at it if it's in the record.
Correct, it is.
So the Neely's counsel, he was the one that asked that the estate be substituted, personal representative of the estate be substituted.
I apologize, Your Honor, you were cutting out.
Sorry, I'm having some mic issues. It was counsel for the Neelys, who was also counsel for the estate. He's the one that asked that the estate be substituted. Is that correct?
It was counsel for my clients, Roger Johnson, that asked at the trial. But in the pleadings that counsel for Mary Neely and her estate filed to open the estate, he indicated the purpose was to finalize this settlement.
Okay. So your client asked that they be substituted, but was anyone else there when he asked that? Was counsel for the Neelys there when this request was made?
No. No.
So was the estate ever given any sort of notice? Were they served with the lawsuit?
They consented to that.
They consented to it?
Yes, correct.
Is that in the record and where?
That would be in the record, in the trial transcript, and in the pleading itself opening the estate.
Counsel, while this discussion has been going on, I've been looking at this trial transcript, which is only 7 pages, not including the certificate. And I'm not seeing in there where there was a request to enter the judgment against the estate. The only counsel that appears is we've got Roger Johnson and Anna Sanderson for the plaintiffs. There's a discussion of evidence. There's a discussion of a number of exhibits. They move to admit the exhibits. And then the court says, I want to review this in light of the case you gave me before I complete anything. And they adjourn.
Yeah, page 6 is the discussion and the admission of the estate documents, opening the estate and the request to complete the settlement agreement.
Okay, they have a document that shows there is an estate. Is there, and you're saying admitting the exhibit is equivalent to a motion to substitute the estate?
Yeah, and I apologize, Your Honor. I'm pretty sure that earlier in this transcript, he reports to the court that Miss Neeley has passed away and that he's asking for the judgment to be entered against the estate. And I just can't put my finger on it at this moment. I'd be
Okay.
sure be happy to provide it in a letter if you'd like that citation.
It's only a few pages, as you know. We should be able to find it if it's there. Thank
Very
you.
good. Very good. Let me
You
take
probably
this-
have other arguments you'd like to
I
make.
do. I actually do. And thankfully, I hope that I have articulated them with respect to coverage in the brief. But I think it's really important for the court to focus on the coverage issue here. This court and the Kansas Supreme Court has written a blueprint for how an insurance company can exclude coverage for damages caused by certain causes, use of an automobile, assault and battery, or sexual molestation. It's they do it in two ways. They've established the Upland Rule, which says that the court will focus on the theory of liability asserted against an insured, and then look at the exclusion and determine whether or not that exclusion unambiguously precludes coverage for that conduct. So the best case, I think, that highlights a good exclusion, a viable exclusion and a not enforceable exclusion is the Marquis case. In that case, you have a homeowner's policy that is very specific and excludes negligent acts. It's an automobile exclusion. It excludes not only use of the automobile, but negligent entrustment, negligent training, negligent supervision, negligent hiring. This was a case that involved an auto accident with the wife. That the wife was the owner of the business and the husband was drinking and driving on the job. And so they sued the wife for negligent hiring, training, entrustment, those kinds of things. So they said the homeowner's policy, because it had that specific language in it, applied to exclude coverage. In contrast, the contractor's policy didn't have that language. It just said use of the automobile. Obviously, the husband was intentionally driving and it was criminal acts exclusion. And so there was no coverage for him. And the exclusion did not unambiguously exclude the wife's negligent conduct, and therefore there was coverage under that exclusion. So the same thing in Jones v. Reliable, which is another really good one. That's on the assault and battery. In that one, the language is set forth in our brief, and it specifically excludes the theory of liability under this Upland Rule. And so that's the blueprint under the Upland Rule for these insurance companies on how they can write an exclusion that will exclude certain conduct, damages caused by certain conduct.
Counsel,
Since
can you explain in this case what your claim is? Negligent supervision, right?
Well, it's negligent supervision, failure to warn, and failure to protect. Yes.
The failures
Essentially
are also
negligent supervision. Yes.
the failures are negligence based, right?
Correct.
Okay, so the only thing though that was not protected against was sexual molestation. Is that right?
I'm not sure I understand your question, Your Honor. I'm sorry.
Right. So the damage exclusion is for anything arising out of sexual molestation. And I'm still trying to figure out what supervision there was that wasn't related to damages that arose out of sexual molestation.
Well, what the Upland rule says is that where there's an independent negligence supervision is an independent negligence, right?
Right.
Where there is that independent negligence, then the exclusion has to be clear in excluding that when you look at the insured who's committing the acts.
Right.
So-
and I'm trying to figure out why it's not clear, I guess. If the only thing that you didn't supervise against was sexual molestation, that a contractual exclusion for anything arising out of sexual molestation would not cover it.
Well, it's actually no different than the exclusions in the intentional acts exclusion and the assault and battery exclusion that, and the discussion in Jones v. Reliable, Raymer and Brumley. Those exclusions also exclude damages arising out of use of an automobile, damages arising out of assault and battery, and in those and under the minority rule in Upland, Kansas courts look to the theory of liability, and if it's an independent negligence theory, separate and apart from the conduct that immediately causes the damage, driving the automobile while drunk, for example, then you have to look at the exclusion and see if it delineates the negligent act that's excluded. Now, you also have the overlay here of the severability clause, which makes it even stronger. And you have to look at both of those rules when you're evaluating coverage here.
Right. I was trying to sever out her potential liability under negligence theory and then understand how that interrelates with the specific language that was used in this contract. But I think I understand your answer.
Yeah. Okay.
Counsel, could I want to go and ask you that question. You probably anticipate this one is there a bad faith claim in this garnishment action?
Well, there is bad faith. And
well, I didn't ask that. I asked, is there a claim asserted? And again, I know you weren't counsel below, but
yeah, there is. That's the basis for the entire judgment, that the Farm Bureau denied coverage where it was clear that under the Kansas law that there is coverage and excess liability, and abandoned its insured and left its insured to fend for itself.
okay, let's hypothetically say we agree with that. I'm not sure that I do or not, but hypothetically, let's say we agree there is a bad faith claim. I'm looking at the journal entry, the garnishment. It doesn't look like the judge decided that. All he decided was that there is coverage. And unless Mr. Thompson misrepresented something to the court, there's $100,000 policy limits. And right now, unless there's a finding of bad faith, even if this is valid, isn't it only for $100,000?
Well, here's what I disagree with that. The garnishment order is for the entire $1 million judgment.
Well, first of all, but I'm asking about, is there any finding of bad faith in this journal entry?
There is no finding of bad faith, but let me say this, that the only two arguments that Farm Bureau has raised with respect to the amount of the judgment are these: that the trial judge improperly raised the amount in the Rule 118 request for damages, and that the non-claim statute limits the recovery to the policy limits. Neither
of which, they've waived the argument that this doesn't even address bad faith, this garnishment order?
I think they've either waived it or it's there's enough of a finding in there and there's evidence in there that there is.
Well, don't you? I mean, don't you? Maybe I'm wrong, but I discussed this with Mr. Thompson. I don't see how there could ever be inherently bad faith. You and I could read the same exact contract language, and reasonable minds could differ on what that meant. And of course, that's why we don't allow insurance companies usually to intervene in the underlying case. That's sorted out then in the garnishment action. Here, it seems like we just completely have circumvented the rules of civil procedure.
Well, I think the distinction is this Farm Bureau has just walked away from its insured. It didn't offer a defense. It didn't.
But did they have, well, I guess that's a fundamental question. I understand that, but did they have an obligation to defend under reservation of rights? Now, 2020 hindsight, they certainly should have, but we don't live the world backwards. We live forwards. So did they have a legal obligation to defend under a reservation of rights?
Well, they could have defended under a reservation of rights. They could have filed a declaratory judgment action to determine their coverage, or they could do what they did and walk away from their insured. And when they do that, then they're stuck with the judgment and they're stuck with what happened in the factual findings under Christ and the underlying case. And, that's the risk. That's a big risk that the insurance company takes. And it's a really big risk in this case where Kansas law is pretty darn clear that there's coverage here. But
isn't Kansas law also pretty darn clear that in a garnishment action, that's where the insurance company can raise their defenses?
The insurance company can raise those defenses, but if they lose,
here they were never heard, were they?
They were heard. There were cross motions for summary judgment on the coverage issue. But
not on the bad faith claim. That's what I'm getting at. You said on the coverage issue, and I agree with you 100% there. Mm-hmm. And that's where I agree in answer to Judge Liebman's question. I think Mr. Thompson said that as far as the coverage, there's a sufficient amount. Because we have the language in front of us. That's different than a bad faith claim that would involve some factual issues, isn't it?
Well, where the insurance company has taken the risk and decided to leave its insured hanging out to dry, it's stuck with the findings, with the underlying judgment. But
that doesn't mean they have to pay it all. I mean, it could have been $1 trillion judgment.
But think about that. Yeah. Think about that, President. Do you want if an insurance company has a so-called good faith belief that there's a disputed issue of coverage, can they just send their insureds out to pay for their own defense, and then at the end of the day gamble and litigate coverage in a garnishment action? Well,
that seems like the argument to be made to the district court, and in all likelihood, perhaps you would win on that argument. But it still seems like that issue needs to be decided.
Well, certainly the fact that that Farm Bureau left the insured hanging out to dry was argued in relation to the summary judgment motions.
Counsel, can I just double check? Judge Bruns brought up the question I asked to Mr. Thompson, and set aside bad faith for a second. Do you agree that all the coverage actions, if we get coverage issues, assuming we get to them, can be decided as a matter of law? There's no factual disputes.
I do agree, Your Honor.
Okay, thank you.
All time is expired, so thank you very much. Mr. Thompson, I'm going to give you some extra time. I'm going to give you an extra 2 minutes, so I'll give you 5 minutes.
Thank you very much, Judge. Let's talk about blueprints for a second. And let's talk about procedure. First of all, if you look at the garnishment order, there's not an amount in the garnishment order. That's also a violation of procedure. Rules in this case just didn't seem to matter at all. But the blueprint that the courts have to follow is this. Both Jones and Bug cases are after the Marquis case that plaintiff's counsel cited. And in Bug, I want to stoop to reading some of the opinion. Plaintiff's theory of liability was immaterial, and plaintiffs could not create coverage where there otherwise was none, merely by pleading the theory of negligence. And in Headnote 5 in Bug, it says, an assault and battery exclusion clause is intended to exclude all claims arising out of an assault and battery. Let's apply that blueprint to our particular set of facts. A sexual molestation damages exclusion clause is intended to exclude all claims arising out of sexual molestation. That's the blueprint that needs to be followed. More recently, in Jones, the court said that the exclusion at issue, which was an assault and battery exclusion, clearly disallowed coverage for any claim arising from assault and battery even if the battery was committed by a third person. Let's reword that to apply to our particular facts. The exclusion at issue clearly disallowed coverage for any claim arising from sexual molestation, even if the molestation was committed by a third person. So the blueprint that you're given from Bug and Upland is to enforce the contract as it's written, and the exclusion is not ambiguous here. The exclusion is very clear that she had no coverage for damages arising from sexual molestation. And there can be no doubt that sexual molestation was the one thing that caused the damages. I gave you a hypothetical of where he didn't commit it. And if he didn't commit sexual molestation, there are no damages to identify. So the contractual deal between Mary and Farm Bureau was, one, the policy doesn't cover everything. Two, there is no coverage for damages arising out of sexual molestation. Three, regardless of any other cause or event contributing to those damages, such as her enabling perversities or choosing to ignore warning signs or choosing to be inattentive to his her safety or choosing to leave her with the petitioner or the perpetrator. Those are all things alleged by plaintiffs that she chose to do all those things. Regardless of that, the exclusion applies. And regardless of whether the sexual molestation is a direct or indirect cause, there is no way to read this policy and this exclusion any different than the assault and battery exclusions in Bug and Jones. And as a result, there is no coverage. That resolves all of the other issues. There are many other issues in this case in terms of the defectiveness of the judgment, but once you determine as a matter of law, based upon the language of the policy and the undisputed facts in the record, that there is no coverage, the case is over, and the garnishment order and judgment should be overturned, and Farm Bureau should have no obligation to pay in this particular case. Does the panel have any other questions?
I see none, Mr. Thompson.
I've got one question, which relates to the procedures on garnishment. And I should have asked this in the earlier stage, but better right before you quit than after you all leave. On the one hand, you didn't seem to get either a reply or a hearing on the garnishment. On the other, KSA 6736, talking about the answer of the garnishee, seems to contemplate that the garnishee, once they answer, will set up a hearing. In the record here, does anybody ever ask for a hearing related to either the issues in the answer or the garnishee, the reply that didn't happen, or was it simply you both filed a motion for summary judgment on coverage, and that's really what the issue was on everything?
That's partially true. The motions for summary judgment were argued. Months and months and months and months went by.
Right.
And a ruling came down saying Farm Bureau loses. No ruling on plaintiff's motion. Months and months and months and months and months and months go by.
I think it was 6 months, so you got that exactly right.
Okay. On February 27th, I believe it was, plaintiff's counsel writes to the judge and says, hey, here's a journal entry. Do you want any more argument or whatever? And within 24 hours, that journal entry was signed and filed, period. Done, case over as far as the garnishment went. No time to respond or anything. I mean, it was less than 24 hours.
But neither party asked for any other hearings that weren't held. So it's just a question of kind of looking at the statute and seeing whether we think things are complied with on your technical error claims. But you did get a hearing on the motion for the cross motions for summary judgment. And there wasn't a other hearing request made by either party over the garnishment.
Actually, if you look at the notice of hearing, that was just to be on Farm Bureau's motion. There was never a request for plaintiff's motion to even be heard. And frankly, it was a little bit of a surprise to walk in and have them argue theirs as well.
Okay.
Your Honor, I know it's not my turn, but in the, just to clarify, in the motion to enter the judgment on the plaintiff's motion for summary judgment, Mr. Johnson and my clients asked for alternatively a hearing on the rest of, on any other issues, either enter judgment or alternatively hearing.
Thank you.
That is correct. He said either sign this journal entry or let's have a hearing. And the judge just signed the journal entry.
Okay.
All right, counsel, thank you very much for your excellent arguments. We appreciate the responses to all the questions that were fired at you today. We will take this case under advisement and we'll try to get a decision out to you as soon as we can.
Thank you.
Thank
Thank
you.